Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. In this edition, we discuss the will interview with an attorney. Now, many times people come and ask the attorney, why do I need a will? Well, if you don't have a will, the state has already written one for you. Your assets go to whoever a state law says receives the assets. Or to the government itself. A will should be a statement to the things you truly care about: your spouse, your children, your parents, your friends, your church, and charities. You can consider remembering a school or church in your will. Now, if you have no will, or your will is declared invalid because it was improperly prepared or is not admissible to probate, number one, people you dislike or people who dislike and ignore you may get your assets. 2. State law determines who gets your assets, not you. 3. Additional expenses will be incurred and extra work will be required to qualify an administrator. There's a surety bond, additional costs, and probable additional legal fees. 4. A judge determines who gets custody of children. A greedy brother or crazy mother-in-law could ask the court for custody of minor children. You lose the opportunity to try to reduce New Jersey estate tax, state inheritance tax, and federal estate taxes. If you have no spouse or close relatives, the state may take your property. The procedure to distribute assets becomes more complicated, and it will probably cause fights and lawsuits within the family. So when people are grieving without death, they shouldn't be overwhelmed with financial concerns, and people should be encouraged to have a will. Think, who don't you want to receive your assets? Without a will, those people could be the ones who receive your assets or custody of your children. Oftentimes the phone rings in our office and people want to know how much for a will, and we say typically it depends on the size of the estate, the amount of work. We don't want to waste our time if someone's just looking for a cheap $45 will, because typically those wills are not done in the modern way and aren't right for most people. Now, many times people have questions. Well, that's what we do as attorneys. We solve problems, we answer questions, but that comes with paying a fee. And if someone's just looking for a free consult, then they're not going to get the best of the attorneys. Typically, with clients, we want them to come in. People need encouragement. And one time, I used to see a friend of mine from high school, Okie, at once a month. And every time I would see him, Okie would say, Kenny, Annie, and I need a will. We got to get a will. And that was in 2001. But Okie worked in the World Trade Center for Morgan Stanley. And the day after 9/11, my office gets a call, and the message is from Okie. And Okie says, I think it's time to get a will. And I call Okie back and says, well, it's good news that you got out. Let me have you come in on Thursday to do the will. And Okie says, well, I'm kind of busy. And I said, kind of busy doing what? Terrorists blew up your office. You have no place to work. You need to come in. It's a call to action to clients. So when someone calls in, we send them an appointment letter. And the appointment letter oftentimes is emailed, and we send them our will questionnaire. And in the appointment letter, we tell them to fill out the questionnaire. We also advise them that there's going to be fees involved, so that they should bring a check or their credit card. So what's basically in this will questionnaire that's sent to potential clients? Well, I'd say not complicated questions like what's your name, where do you live, who are you referred by, I'd say are you married. Also in the first page we indicate we recommend a durable power of attorney in the event that your physical or mental disability happens, and we recommend a living will. And we put that in bold because oftentimes when we get a call from a family member during an illness and they ask to see if the person has a power of attorney or a living will, I'd say we either want to say yes, we have one, or fortunately sometimes we have to say no, they checked off, they did not want to have one. The next page of the will questionnaire asks questions such as, first of all, what are your questions? And we ask that more than once because many times people have questions. We do require that the form be filled out by the client in their own handwriting. We're concerned with RPC 1.7, which deals with conflicts of interest, and we're also concerned with the Stockdale case that held an attorney possibly liable for punitive damages where they participated in the drafting of the will, where it was later declared that there was undue influence involved. We ask for the person's marital status because sometimes in the prior page they don't put down a spouse. We also ask for their date of birth and social security number. Importantly, the next part which they need to figure out is who do they want to be executor number 1 and executor number 2. And as an executor, we ask them, are they able to do the job as executor? I'd say, and that's sometimes someone gets has a will, but the person they've picked as an executor is old and no longer able to do the job. I remember my grandfather was an executor of his cousin's will, but when my grandfather was 92, he didn't run up a flight of steps as fast as he used to. I don't recommend joint executors because there's a reason why we don't have 2 presidents at the same time. The page 3 of the will deals with assets, and we ask them to deal with like real estate, bank accounts, stock, and importantly, which assets have direct beneficiaries or in joint names. It's important to explain to the clients which assets pass by title outside the will. House is often owned by husband and wife, tenants by the entirety, so it goes automatically to the spouse outside of the will. Bank accounts sometimes are in joint names and go to the survivor. Other assets pass by matter of contract, such as IRA, 401k, life insurance, annuity, pension plans. We want to find out which of the assets pass directly out by contract. And then next we ask, who gets your stuff? Who gets your assets? And also if there's specific bequests, if there's any specific item of value that they want to go to someone specifically, and tell them don't rely upon what you might have told your daughter. For the same thing, if you don't want someone to get something, be clear. I want nothing to, and the name of the person. Now occasionally, someone may say, well, I'm married, my accounts are in joint names, why do I even need a will? Doesn't everything go to the spouse? Goes, yes, but unless both of you are going to live forever, we need a will for the second person. We also want to know the ages of the children. Page 4 of our form, if someone has minor children, who would be guardian number 1 and who would be guardian number 2. Let's see, the trustee is the person who holds the money for the minor children. The guardian is the one who holds the children. So sometimes we have to ask, who do you want to watch your children next week if you can't come home? And who don't you want to watch? And that's, and lastly we ask again, what questions does someone have? Let's see. Finally, let's see. It gets to, and you go to, are there any special needs of any of the children, because you don't want to ruin someone's entitlements to special needs because and lose any Social Security, other income that they may have, a child may be getting. We have looked at the bottom to see who filled out the form, and we go to how will you pay. And we also advise most of our clients now that we don't do sufficient sophisticated tax planning. We don't do Medicaid planning as part of this, and if they need that, we'll refer them to someone who does handle that. All the clients get what's called a will bill that sets forth what they have to pay.